Good morning, everyone, and welcome to the first discussion that's going to be hosted on my channel. It was originally supposed to go live, but YouTube has unfortunately prevented me from doing such and has placed me under a 24-hour waiting period in order to have the privilege of live streaming. As such, this conversation is going to be recorded. It was originally supposed to go live at 8 o'clock a.m. Saturday, June 25th. But hopefully you will all be watching this later in the evening. I would hope it would go out before tomorrow morning. Anyways, without further ado, I am joined by Matthew, otherwise known as the Prudentialist, the man that made this happen at the last minute in spite of all of the issue. Say hello, Matthew.
Good morning, everybody.
How are you doing?
I'm doing quite well.
Wonderful. I'm also joined today by Christopher Sandbatch. How are you doing, sir?
Pretty good, man.
Wonderful. Now, I don't know how much of my audience will necessarily know who you are, so I think it would be apt to describe you as an American historian with a special aptitude towards the American South. Would that be fair?
Oh, me? Yeah, that's me.
All right.
Yeah, that's me.
All righty.
I don't believe I qualify as a historian, so.
Yeah. Right. Well, I was curious. I was like, nobody's actually called me that in a long time. So I was like, that's me. Yeah, American South, that's me. Yeah.
I am in the South, though, so there is that. That's correct.
And I'm also joined by Mr. Corey Mahler, if I have got the last name pronounced correctly. How are you doing,
correct.
sir?
I'm doing well. How are you?
Wonderful. I'm doing very well, and I am almost certain that most of my audience will not know who you are. I'm fairly certain you're a very new voice to most of my audience, and probably the audience of Mr. Prudentialist and Mr. Sandbatch. So I believe it would be apt to describe you as an attorney with a penchant for pointing out people that just go along with the modern culture.
Yes, I think that's a fair description.
All right.
I think the degree behind me will probably clue people in on the attorney part. So,
wonderful. Alrighty. So it should hopefully be no surprise that we are discussing today the Supreme Court decision to overturn Roe versus Wade. And this is not a law-focused channel, so if you want to get a full overview of the entire opinion, this is not the place for that, though we are going to be hitting highlights. Before we dive into that, though, I would like to get everyone's opinion on this happening. Very summary, a preliminary would be good. We'll start with you, Mr. Prudentialist. What are your thoughts?
Well, as I had said last night with Pat Casey and friends, I think that this is a good moral victory. The question becomes whether or not that our political organizations, being that the pro-life movement is probably one of the most well-organized and well-funded in the country for the right, where this goes next. I know that there has been legislation proposed in the House of Representatives, along with I think Jim Banks from Indiana was leading it, talking about, well, they should take the culture war to the next step and have adults who have detransitioned the legal right to sue doctors that helped them transition as minors. So perhaps there's hope there, but overall, I think that this is a good moral victory for those that oppose abortion and oppose murder of children. So we'll see what happens next, but it's a good moral victory, and I'm happy for it.
Alrighty, wonderful. Mr. Sandbatch, do you have any opinions on any preliminary opinions?
Well, I think it's always a good thing when people stop scraping embryos out of uteruses with rusty scalpels and that sort of thing. But I think the bigger take-home message, because especially if you look at the entire docket of Supreme Court cases that came out and the federal response to them, is we had this issue with this gun issue, or it was a gun issue in New York, and the Merrick Garland came out and said, essentially said, well, the courts have made their decision, now let them enforce it. And they're going to continue to enforce the anti-gun laws in New York. So I think if you take the real takeaway message, I think from the overturn of Roe v. Wade and the gun and the right sort of backsliding on guns, is that really we're seeing what has been the paradigm of American politics more or less since Watergate is starting to shatter, because the contested ground is disappearing. So the right backsliding on guns leads to the idea of the left attacking on guns. Whereas, somebody said it best the other day when it says, the right didn't win a victory yesterday. We sank their battleship. Okay, so this is So the left loses on one huge issue and wins on another issue. The right loses on one issue and wins on another huge issue. So I think the amount of contested ground in American politics between these two factions that have been in charge of it since around 1974 is the real interesting takeaway here. That was a lot at once, sorry.
No, that's fine. And if we have enough time later, unfortunately, I am slightly constrained to about 2.5 hours this morning. There were other decisions that were released just before Roe v. Wade, the day before in particular, discussing gun rights with the New York case, but also Miranda rights as well. So I'm sure if we have enough time, we could probably talk about those, being as they will most certainly be overshadowed. But anyways, Mr. Mahler, your opinion, please.
Well, I would echo what the other two gentlemen said, that this is a victory. Of course, it is going to depend on how much we can capitalize on the victory, because the goal is to maintain the momentum and win additional victories. It's not to rest on your laurels because you happen to win the overturning of Roe and Casey. Part of it will also depend on what the court does in the future with some of the things that were said in this particular opinion, particularly in the concurrence from Thomas, because he has obiter dicta in there where if that's an indication of where future cases will go, then those could be major victories, overturning homosexual marriage, overturning various other things that he mentioned. But those don't always become the holdings in future cases. Sometimes they're just throwaway comments from a justice, but it depends on what the future will hold for that. But again, it is a victory. It's important to see it as a victory. You have to celebrate your victories because that's how you keep morale up on your side. But you can't just rest once you have that victory. You have to keep pushing forward. And the right has a tendency to sort of declare victory and then go home, and that's not what you do here.
Right, and I think we'll all know what you're talking about whenever you say that. So I think it's fair to characterize then that there is a lot of hope to be had from this particular event, which is not something that a lot of us are used to on the right, especially in the last 2 decades or so. In my opinion, very short and simple, I am personally very happy for this. And I really dislike immoral laws on a very personal level because you can, if you go through the school system, you can see families just ravaged by this stuff, and that really just kind of hurts me on a very personal level, just having to live with those people, because they are people after all. It is harming them, and they're being told that it's a good thing that it's harming them by most authorities, which leads them in their education to mostly not know any better. It's a very malicious thing that's happening. That's my basic opinion, while also concurring with the other 3 gentlemen. Now, so the opinion had a few places that caught my eye in particular, and Mr. Prudentialist, I believe this will be the first screenshot that I sent you, which should be our Chief Justice, if I'm not mistaken, basically talking about the court not possessing authority to declare prohibition or a right to abortion. And to me, this seemed rather significant because it seemed like he was basically getting dragged around by the other, quote, conservatives on the court. It seemed like he didn't want to go as far and basically just had to declare a very technically correct, but also sort of milquetoast statement here that basically just said he is not supporting the momentum here, and he's just going to fall back on very technical law, that the Constitution is silent on this, and therefore he's not going to go one way or the other. Now, anyone tell me if I'm being unfair, because law is not my specialty. This just caught my eye. Anyone that wants to chime in first? Or we can just go down the line. Is that an unfair statement, Mr. Mahler, and then we'll go up through the line?
I don't think it's particularly unfair. I mean, it is an accurate statement. The court is not supposed to create rights. That is a technically, legally true statement. The court is supposed to interpret things that are written by others.
Alrighty. And Mr. Prudentialist, was that an unfair statement on my part? Any thoughts?
No, based on what I was reading yesterday and discussing with sort of the legal right on Twitter, it seems that Roberts was taking a very careful position to sort of stake out that he doesn't necessarily agree with the declaration that, the court deems something, not a constitutional right. So I think that that's pretty fair in this regard.
Alrighty. And Mr. Sandbatch, was my statement unfair?
Well, no, I don't think it's unfair. I think Justice Roberts probably wanted to get rid of you, probably agrees more with the spirit of the decision than he was willing to let on. But he kind of likes to play this, like, I guess you could say, big brain centrist role. And so, I mean, it's prevarication's not unusual from him, because he likes to imagine himself as like the swing vote, the guy at the crux of the court who decides things one way or the other, and likes to imagine himself as a very important person. And that's kind of how this comes off,
Right, and
he's the new Kennedy.
Right, and pardon my cynicism here, but that seems to me to be a very sort of weak leadership role. He's like, his title is supposed to be Chief Justice. He's supposed to be the one that's at the very least a figurehead leader in the court in the minds of most people, and here he is playing a swing vote, which is a very sort of precarious situation that you just get led around on one group or the other that is admittedly stronger than you, making you the swing voter. To me, it seemed like a sign of weakness from him. But once again, law is not my specialty.
Well, he is, leaving aside perhaps whether or not he's politically compromised, he is in the same vein as Kennedy, the sort of man who likes to see things nice written about himself in the New York Times, which you don't get if you are on the actual right. So he likes to play the little game where he'll go one way or the other depending on how he thinks he's going to be perceived at cocktail parties later. That's part of it. But also, it's not necessarily always a position of weakness to play that role, because often one of the ways the court will get that fifth vote on board is giving them the decision to write. That didn't happen here, so obviously they didn't need to bring him on board that way. But sometimes it can be a position of strength, because if you get to write the decision, you can put some things in there that would not otherwise be there. You have a little more control. Kennedy liked to play that game.
All right, that makes much more sense. Mr. Prudentialist, Sandbatch, any more thoughts on that line of reasoning?
No, I mean, that's pretty a fair description. I've kind of viewed him lately, since the court has swung more to the right in the last few years, that he's played more of a almost like a John McCain style maverick role, where he's very outspoken about judicial independence. He's outspoken about that the court is this sovereign body that won't be swayed by sort of the pressures of the political wills of the day, and that it will act the way that it should. But I mean, again, he's also well more established, I think, than the other two when it comes to, or the other members of the court when it comes to, say, speaking arrangements or being more mindful about what is written in the press about him.
I'm actually reading this.
Hold on. Mr. Sandbatch, you are exceedingly quiet on my end. I don't know if that's coming across that way for anyone else.
Oh, I had my microphone covered up.
There we go.
It says here, the court therefore does not possess the authority to either declare a constitutional right to abortion or declare a constitutional prohibition of abortion. Okay, this is technically correct. And there's a bit more, and I was talking to leftist lawyers about this, because of course I was in a law fraternity, so I know a bunch of leftist lawyers, and they were absolutely psychotic about really more Roberts than they were. More Roberts than they were Justice Thomas, because this was an unusual. There's more radicalism in this statement than there initially appears to be, but I think we'll probably have to wait until we get into the substantive due process question to sort of unspool what it is. But that is a statement in direct contradiction of the doctrine of substantive due process, which is, that's a little bigger than it initially seemed whenever I read it.
Wonderful. Alrighty. So with that foreshadowing there, we will go to the next screenshot that I sent you, Mr. Prudentialist, which should be the one starting on page 1 and then ending on page 2, which is just the beginning or the outline. This was the next thing that caught my eye when going over it, because, forgive me, I can't read this thing front to back. I just have to go to sort of the highlights. But this is sort of the historical precedent, if I understand correctly, that the court was resting on, or at least a summary of, where it goes through basically how things might have been before 1973, and then it talks about 1973 kind of uprooting that, and then it ends it basically discussing, it ends it with basically an accusation that everything was completely inaccurate and wrong in the 1973 opinion. So, yeah, this one. There we go. So it starts for the audience at home. The quote starts, "For the first 185 years after the adoption of the Constitution, each state was permitted to address this issue in accordance with the views of its citizens." So we'll stop there just a second, because that's sort of the pre-Roe paradigm that it's talking about here. Mr. Sandbatch, being as you are a very nice historian when it comes to this sort of topic, can you give a brief overview for the audience? What was the law like in regards to abortion in the common law tradition, in the American tradition? How was this treated before Roe? What's the summary there?
Well, the common, according to common law, and this is goes all the way back to Edward Cook. The common law tradition dictates, a set of laws that are, we call them statutory laws, and they've shifted around a little bit. So it's they're always trying to answer the question: at what point does something become a human? And really, for a lot of reasons, they fix the age around 16. But on the subject of unborn children, they had a standard where after what was called quickening, it was considered, the fetus is considered a person. So this is really before science or anything like that has spent much time delving into what exactly pregnancy entails. They had this idea that when the child shifts downward in the womb and is in preparation to be born, that at this point that fetus is a human, and it has, and it can be treated the way humans can be treated. But it falls in a kind of legal gray area still, because it's not quite an adult that has all of the privileges and rights of Englishmen, if I could put it that way. But that's more or less been the settled opinion on it, is that, okay, there's a common law argument for pre-quickening abortions. Okay. There is one, because this isn't really a person before that, according to the law. But for most of American history, this has not been an issue that has incited much controversy one way or the other. This is one of those things. It's illegal, but if it happens, it happens, is kind of what the opinion of American lawyers. They would be considerably more likely to go after doctors who were serially performing abortions than they are to go after individual persons who are performing abortions. And that's still generally the way courts have attacked the situation, especially in southern states that hew a little bit closer to the common law tradition. So, really, in a lot of ways, people aren't behaving that unusually, especially courts and the lawyers that represent the various factions in courts have actually taken a much more common law friendly procedural tone towards the issue than people may have expected they have. But the mania surrounding abortion on both sides it's very new. And so you've had this really strange situation where the two camps on either sides make arguments that don't necessarily pertain to the legal issues at stake. And that's kind of been the way, abortion has worked, especially in the last 50 years or so.
Just to get one more angle on that, before I ask our next panelist to discuss his opinions on the quote there. what was society or the cultural view of abortion during this time of common law? Because the law can say one thing, but oftentimes I've seen in history, most people would think another thing. It would be the law might have something as legal, but no one would ever participate in it because it might be seen as extremely shameful and immoral. Things along those lines. So, was society fairly the society at the time before this amendment, going all the way back to common law tradition first emerging? Would they have agreed with the law? Would they have seen these things as shameful and immoral? Would they have seen them as good?
Absolutely shameful. I mean,
right.
This is one of the things that would have barred you from participation in what was called civil society if
All
it
righty.
was known that you had done something like this. Yeah.
Alrighty. So, now that we've got both of those angles, the law and society, Mr. Mahler, would you like to comment on anything that was just said, or the quote about the pre-Roe legal tradition?
Well, one of the biggest things, and the court does note this in the opinion we're discussing, is that essentially what happened with Roe and then was upheld with Casey, because Casey didn't go back and actually really re-examine anything. It just upheld it under stare decisis. That most of the states banned abortion in some form. It was 3/4, give or take, banned abortion in some form at the time Roe was passed. So this was another one of those instances where the courts took it upon themselves to shove through something that had already been routinely rejected by the legislatures and the people, depending on which state. The same thing happened, of course, with homosexual marriage. It happened, for instance, in California. Basically, not very long after the people passed a proposition saying, no, we will not have this, the California Supreme Court came and said, yes, you will. And that's sort of how it happened in California and a few other places, because essentially that went down to defeat everywhere it went up for a vote or was presented to the legislature. And the same thing happened here for abortion. You went from having 3/4 of the states, give or take, banning it to it being legal in the entire country because the Supreme Court found a right to it, a quote unquote right to it. And so, yes, the comment on the common law and quickening, that is essentially how that worked in English common law. I'm not as actually familiar with how it worked on the continent, but I would imagine there was some similarity there, probably passed on from Roman law in that case. But it was also interesting that the court decided to take something that had long been delegated to the states under the 10th Amendment and other such things and just make it a blanket law for the entire country instead of leaving this to be a matter that was a states' rights issue, whether or not states decided this. But of course, the court is to some degree right with that particular logic, not with the outcome of the Roe decision, but with the fact that if this is an issue of individual rights, and here it's the right to life, then states do not actually have the right to determine that. And so that should be a uniform matter across the country. Of course, they got it wrong initially. They've somewhat amended it now. They didn't ban abortion, they just tossed it back to the states. But so those would be two of the strange things, as it were, about Roe. But that's how the left has worked for a long time. They have shoved through things in the courts. They don't recognize that now, and that's why they're up in arms about this, and they want to get rid of the Supreme Court because they don't realize they have won for a century in the Supreme Court, and now they get a little pushback and they're insane.
Alrighty, and Mr. Prudentialist, your thoughts on that, on the first part of that there quote, and then if there is more discussion to be had on it, we'll let you all converse, and then proceed to continue reading the rest of this excerpt.
I'm not the how I read this is not anything that I think is too out of the Overton window here. Just that this has been kicked back to the states, sort of to a pre-1973 ruling. To me, it does kind of show some of the interesting part of sort of the trend that we've seen. Really, I want to say probably since the 1960s when we had Clark v. Griswold. Just one, the substantive due process question, which we'll get into, but also just the chipping away of sort of the states' rights issue of under the 10th Amendment, where there is now sort of these blanket policies that are or aspects of law and rights that are now being imposed upon the rest of the country and not being decided by the consensus, or dare I say, the popular sovereignty of the people. And it just is interesting to me to watch the federal government sort of continually through the courts basically uphold the constitutionality of sort of this coercive federalism, whether it be, say, this decision Roe v. Wade back in 1973 to unfunded mandates that we see all the time in Congress.
Alrighty. Now, do any of you have any comments to something that the other person said? And if not, we will continue reading. But if you do have comments, please do speak now. All right.
I love how you're running this like it's Robert Rules of Order.
I thought this would be like the very ordered discussion as opposed to the more free-flowing ones that we can find elsewhere with our friends. So the quote continues, then in 1973, this court decided Roe v. Wade. Even though the Constitution makes no mention of abortion, the court held that it confers a broad right to obtain one. It did not claim that American law or the common law had ever recognized such a right, and its survey of history ranged from the constitutionally irrelevant, e.g. its discussion of abortion in antiquity, to the plainly incorrect, e.g. its assertion that abortion was probably never a crime under common law. So this is the next part of this excerpt that I wanted to talk about, because this is summarizing what the rest of the opinion delves into in detail, if I understood correctly when I read through parts of it. The claim here being that the 1973 decision completely overturned all this tradition of common law and American law, since common law, that we just elaborated upon. And it also basically just says what some of our guests here just said, where it completely goes against the legal structure of the Constitution by just mandating a broad right where there's no mention of one. So let's start this with Mr. Mahler. Any thoughts? Any thoughts on the examples it gave, on any implications? You, sir.
I wouldn't necessarily say that historical information is entirely irrelevant, because there is a certain continuity with our laws from ancient times. We have even in more so on the British side of things when it comes to the common law, but we used to cite back to Roman jurists and antiquity, the Middle Ages, all of these things. And so that's not necessarily out of the ordinary. Does it have bearing on the interpretation of the Constitution? That's a little more tenuous. But the men who wrote it were versed in these things. They would have known that. But that's actually an argument against there being a right to abortion. They would have been aware of these things, yet it's not in the Constitution. And so arguing, you're sort of arguing from silence there, but in reverse. So it doesn't, the historical argument doesn't work to create this right to abortion, because if the authors of the Constitution had wanted that in there, they were aware of the historical practice, they were aware of the present practice, they didn't address it. They left that to the states. But otherwise, it's essentially roughly what I said earlier about going against the actual consensus in the country at the time.
Alrighty. Mr. Prudentialist, your thoughts?
I don't have too much to add here, other than the fact that history, of course, is going to be important in both regards to just how our common law system operates, and I'm in concurrence with Mr. Mahler here.
All right, a wonderful reminder. Mr. Sandbatch, your thoughts?
Where history becomes important here is because, and this is part of substantive due process, is that, and you would see this, we saw this every time during the Trump administration. Whenever they would confirm one of these new justices, they would ask a very specific question every time, which is, do you believe Roe v. Wade is settled law? Okay. One of the tests that a law has to pass, one of the to qualify, in jurisprudential thinking for substantive due process, is that there's a question of whether or not something is historically and traditionally a part of the American body of law. Okay, and that's such a dicey question. How do you even answer a question like that? Well, it turns out how somebody answers that question becomes very important. And people will argue this is actually a much older argument than it really appears to. People who argue that the founders, they were, because the founders were aware of this practice, because they didn't say anything about it, says this about them. And I think how you come down on that question, I mean, that's a very real question of jurisprudence, because we've elevated this to the question of a legal test. Okay, how you answer this question about history ends up being very important about the way to the way you're going to go about answering it. So I mean, it really is in many ways a historical argument.
All right, and just to make sure that we can elaborate upon that thought, they did answer that in this little summary text, I do believe. So what does it say about them in particular? What are the implications of this? Mr. Sandbatch.
It's we'll have to read it now. This was probably after cataloging a wealth of other information having no bearing on the meaning of conscience, the opinion concluded with the numbered set of rules, much like those that might be found in a statute. This is. I want to say this is. I don't know enough about like late 20th century jurisprudence, but it seems like to me this is a pretty like concrete statement of originalism. I don't know. You have to ask the actual lawyer about that. But it looks concurrent with like the way, especially the influence of Justice Scalia exerts itself on the court. That reads like his thinking more than it does anything else. But I don't know. I don't know enough about that topic.
Alrighty. All right. Before we hop off topic, Mr. Mahler, any last comments on Mr. Sandbatch's comments?
I mean, I could make a general comment on stare decisis. In some regard, stare decisis is important, but it has been treated as more important than it actually is. More or less, stare decisis should, I would argue, be taken as one source of warrant for a particular conclusion. It shouldn't in and of itself be conclusive. That's been argued in legal journals a number of times in a number of places. But if you permit stare decisis to have the final vote or a veto, all you're doing is setting up irresolvable conflict in the future, because some decision made at some point in the past is now unalterable by normal means. And that's not a good way to run a legal system. Particularly, you may encounter a novel issue that if you adhere to stare decisis, the issue will be decided incorrectly. And if you have this iron rule of we have to agree with these old opinions, well, you can't address these new issues. And so I think the court is in some way revisiting how they treat stare decisis, maybe in line with some of the literature published in legal journals, and I think that is a good thing. Of course, the left will hoot and holler about it. They don't ever follow stare decisis. They just use it. They pick and choose here and there whatever they happen to like in order to reach the conclusion they want. They are not happy because now maybe the right is doing something a little bit akin to what they've been doing for a very long time.
Alrighty, and just for anyone in my audience that might not know, American legal tradition and law and legal structure, could you explain to them what stare decisis is, very briefly?
Stare decisis is just legal Latin, which essentially means let the decision stand, let the thing decided stand. And the essence of it is just that you do not, at least arbitrarily, overrule old decisions. Old decisions are supposed to stand. They are supposed to be the foundation on which you build future decisions. That's how the common law works. The common law, you have a foundation of various norms that came from various places. Then you have interpretations of them by cases, and additional future cases build on that foundation. Becomes a little wieldy over time if you have to read back several centuries, but that is essentially how the common law works.
Alrighty, thank you very much, Mr. Prudentialist. If our Mr. Sandbatch returns, could you please let him back in?
Will do.
Alrighty. The next piece of information that really caught my eye was it went sort of viral yesterday. It was Justice Thomas's concurring opinion, where he starts to talk about other decisions by the Supreme Court. And I believe this is where we will get into the topic that I especially had Mr. Sandbatch on for, because the concept that he keeps mentioning, substantive due process, this is what ties in all of these cases mentioned by Justice Thomas together, particularly, and correct me if I've read it wrong, not only does it tie in Roe v. Wade, but also Lawrence v. Texas, Obergefell versus Hodges, rather, and there was another one going around as well. Was it Griswold?
Yeah, it's Griswold.
So, Mr. Sandbatch, why don't you tell us what this fascinating legal topic is? Then I will probably go to Mr. Mahler to get some elaboration, and we can discuss what this means for all these other very important decisions from the court.
Well, substantive due process is an idea. I think it was it first crested above the waves in 1852, I think. But it's actually a concept that's much older. Most people will date it to the 1905 case. I think it's Lochner. It's either 1905 or 1906. Lochner versus New York, in which you would think the substantive due process, it's become so associated with left-wing jurisprudence that you would think Oliver Wendell Holmes is the guy that brought it, that spirited it into existence, but he wasn't. He was actually in the dissent.
Right. I want to cut you off real quick, but what is it for those in the audience? And
substantive due process is essentially what used to be called the vested rights argument, which is the idea that if the Constitution doesn't explicitly mention something as a right, can we find other corroborating rights that indicate the existence of a right that the Constitution implies but does not explicitly state? And then it has a couple of other permutations, but it's actually one of the oldest arguments in American constitutional theory. It's been traced back to, and this is kind of how my interest in it comes along, because it really emerges in the 1848 arguments about how to treat slavery in the federal territories, which is that, my spirit animal, John C. Calhoun, was always making arguments that this is a fatal flaw. This is a fatal flaw in the American Constitution. Its inability to deal with situations that it does not explicitly name. And he made the argument constantly that the question of whether or not slavery is protected in territories where slavery is not explicitly legal, but the persons are citizens of states where slavery is legal. Okay, so and it eventually feeds into the Dred Scott case, which is arguably one of the first applications of substantive due process. It was all called vested rights back then. Substantive due process, it enters the lexicon in 1905 and under the guise of labor law, actually. The original, the foundational case where the phrase is used is one in which substantive due process is used to enable workers to essentially cross union lines and contract freely. And the court this is the late 19th century, early 20th century court was pretty divided on labor issues. That was those were the divisive issues of the day. And this concept, substantive due process, was used to make the argument that the Constitution implicitly protects a worker's right to contract their labor freely. And for the next 20 years or so, it remained that way. But it really took a turn, like everything else did in the progressive era, under FDR's regime. And it was the case was, I think, in 1938. I want to say it was a case called the United States versus Caroline Products, which was a very strange case involving the government's ability to ban or to, unless it was an interstate commerce clause case, where this product called filled milk, which is just disgusting stuff, where like milk has had the fats replaced it's had its natural fats replaced by artificial fats, and it was a product that was being sold. And the majority opinion in that case came to the conclusion that the government does have the right to like impose broad bans on the interstate. I think this was what it was broad bans on the interstate like buying and selling of products between across state lines, based on a substantive due process argument that exists within, I think it was the Interstate Commerce Clause and a couple of other directions. But that was the moment at which it became it became a weapon in the hands of explicitly the political left. And the first time it really the first real high profile case, though, was Griswold v. Connecticut, which was I think 1965 or 1966, which is like right at the moment when everybody, that line in the sand where all of the bad lines start going up and all of the good lines start going down. And that was the case where substantive due process was employed to make an argument that that couples had the right to purchase contraceptives. And then of course 5, 6 years, 7 years later, it was applied in the Roe v. Wade case, and it has been the left's go-to trick for everything since then. Obergefell versus Hodges. Can we do enough weird argumentation in case history can we read the Constitution sideways and upside down enough to find protections for usually explicitly? And this was the other thing that came out of Caroline Products, it's footnote 4 in the Caroline Products decision, where they come to the conclusion that in the future this court is going to make more activist decisions to protect explicitly discrete minorities, discrete underprivileged minorities, underrepresented minorities. So even that stuff is way older than people think it is, but it dates to about 1938, and that's kind of that's the whenever this wave gets rolling, and it becomes important for us today because substantive due process was Justice Scalia's that was the windmill he was always tilting at, and I think almost every conservative justice on the court today was affiliated with Justice Scalia in some way, except maybe for John Roberts. He's a little bit older, but I think almost all of the new judges were, they clerked for Scalia, or they have Justice Scalia, the stickers on their MacBooks and that sort of thing. So really, the idea of killing substantive due process as a concept because he despised it that's kind of Scalia's white whale, and it looks like he might be about to get it from beyond the grave.
Alrighty, thank you very much. Mr. Mahler, your thoughts?
One of the terms with which you should be familiar when it comes to substantive due process is one that those on the court who are seeking to conjure things out of thin air are particularly fond of, and that word is penumbra. And what their argument is that certain parts of the Constitution or our legal history create a shadow, and under this shadow you can find other things. Of course, these other things just happen to be whatever it is they wanted to find when they started looking, but that's how substantive due process works. So substantive due process, as was mentioned, you have the Lochner era. It starts out and then it winds up being in Caroline Products. It protects the first 8 amendments and then the things that flow from them, arguably, through the 14th Amendment applied to the states. And so the argument is, if you can find a right that falls under the shadow of one of these actual rights listed in the Constitution, then the Constitution also protects that right. And that's how you wind up with the right to privacy, so-called. Now, I don't disagree with a right to privacy. How the court has formulated it is problematic, but there are rights to privacy in many of the states. For instance, California has a constitutional right to privacy. Actually, not certain if Tennessee does, but so you have a right to privacy as a thing, but the court used it in order to ground these other supposed rights. And so you have Griswold v. Connecticut, which was mentioned, which is the case that basically said you are permitted to have contraception. The state cannot tell you no, because that's a right to privacy. That was the same supposed right under which Roe was found. You have a right to privacy, so the state can't come in and tell you, no, you can't have an abortion because that's a matter of privacy, which is, of course, completely insane logic because that's not what is at stake in Roe. And then you have Loving v. Virginia, which was interracial marriage. And then more recently, you have Obergefell, which is homosexual marriage. And so, yes, Scalia and others have had problems with substantive due process because effectively it is just a blank check for the Supreme Court to do as they please, because you can find anything under these supposed shadows.
Alrighty, very nice. And I will ask the whole panel, feel free to jump in after I ask, what do you all think will happen from here? Because he's listing off court decisions that are very sacred to the modern left. And you can see them freaking out all over social media. If you know them in real life, they might even be seething about it in reality. So, what happens now? Do we think that the Supreme Court will actually go on and review those decisions? Will they sit on them? Will they just go at them very half-heartedly and just revise parts of them? What is most likely to happen for those of us who knew nothing about the Supreme Court until Roe v. Wade was suddenly overturned?
Well, the Supreme Court generally won't do anything unless a good case is brought to them. So a big part of it is going to be groundwork by others, finding a case, setting it up properly, going through the proper, this of course can take years, going through the proper channels, through the proper sequence of lower courts. And so you have a strong case that you then appeal to the Supreme Court because you want the Supreme Court to take that case. And the question, that's the biggest first question, is whether or not the Supreme Court will even hear the case. A lot of times they simply will not hear the case, and then the lower court's opinion stands. And there are ways you can essentially force the Supreme Court's hand. How it usually works is you have what's called a circuit split. We have in the US at the federal level, you have circuit courts, and then you have district courts under those. And the circuit courts are not entirely autonomous, but they are somewhat autonomous. So they can come to different conclusions on the same issue. And if you have that happen, that's called a circuit split. And the Supreme Court is the only arbiter that can resolve a circuit split. So if you have that, you can sort of force the Supreme Court to take your case. But as I was saying, if you don't have a proper case set up to bring to the Supreme Court, they will not even consider any of these issues. Now, of course, it may be the Supreme Court wants to consider them, but at the same time, these are not, well, okay, maybe in some cases they are, but these aren't stupid people on the court, generally speaking. So they aren't going to pick a case that is a terrible case for the conclusion they want to reach. Because if you pick a terrible case, you wind up with a very weak precedent that can then be overruled later or just falls apart. And so they want that strong case with the right fact pattern, the right law in question, in order to address these issues. So if we bring something like that to the Supreme Court, which is the goal of certain legal groups, is to find these cases and then shepherd them through the system. If you find that, yes, we could probably get the court to reconsider some of these cases. Now, which ones will the court reconsider? Some are far more likely than others. You are probably not going to get the court to revisit Lawrence v. Texas in any time soon, or Loving, certainly they're not going to revisit anytime soon. But Obergefell, you could probably get the court to reconsider, because the exact same logic that you have present in this case for Roe is present for Obergefell. Arguably, perhaps even stronger, Obergefell being the homosexual marriage case. One of the reasons that it's arguably stronger is that you have the people through, whether it's usually a proposition or the legislature acting, you have them explicitly saying, we will not permit homosexual marriage in our state as a reaction to it being pushed. So this is an explicit rejection. It's not even that it just happened to be established from long ago precedent, like in the case of anti-abortion laws. This is something that people undertook with the explicit goal of saying, no, we don't want this. And so it is the exact same logic that would apply in a case attempting to overturn Obergefell and toss whether or not states recognize homosexual marriage back to the states instead of having it be a federal issue.
Alrighty, and Mr. Sandbatch, your comments, and then I'm going to go to Prude because I think Mr. Mahler's comments tie in very nicely with the next topic I wanted to discuss.
I think that's more or less what I would say, but I will point out that, okay, Loving again. First of all, was Lawrence v. Texas? Was that the secession case?
No,
What
sodomy laws.
Okay, yeah. Well, anyway, with the way substantive due process was framed in Roe v. Wade is especially grisly. Okay. And this goes back to, this was a time before, because, like all the arguments about where life begins and all that stuff, that's how actually all that dates from the late 70s. When Roe v. Wade was actually decided, and they end up, you'll see a lot of, again, because the reason I went back to Cook earlier, the founder of English common laws, because this was a case that involved a lot of wrangling with very old ideas of what common law was. And the eventual decision is more or less based on the idea that the woman who's carrying this child, she virtually represents the statutory rights of the unborn child. And so their court very literally ruled that this child does not have the right to decide whether it lives, that decision rests with the mother. And you've seen some left-wing argumentation that has kind of gone mask off with this take, especially in the last few days. Newsweek ran that thing where it's like, we need to talk about how abortion involves killing, and that's okay. Because that's the last line of defense for abortion, is that, okay, yeah, we're killing this kid, but this kid doesn't have the right to decide whether or not it's alive. Roe v. Wade was especially vulnerable because if that case is brought in, if the left is forced to fall back on that argumentation, they lose in the court of public opinion. They lose in the court of nearly everywhere now because it's so grisly. I'm less optimistic on Obergefell and especially on something like Loving versus Virginia, because you don't have to make an argument that just triggers the disgust reaction in most of America. Okay. So you don't impact the moral authority of the court by dragging this argument into the public sphere as much. So I think crafting a case that will get around Obergefell or Loving or something like that is considerably more difficult, because the status quo is far less disgusting to most Americans than it was in Roe, if you actually drill down on what the issue is.
All right. Well, actually, before we move on, then, Mr. Mahler, do you have any comments, or Mr. Prudentialist, do you as well? I don't want to keep you silent the whole time, either of you. Before we move on, if you do have comments.
We can probably move on. One quick comment. In the case of Obergefell, if that were taken up by the Supreme Court, it would just be the same thing that happened here. They would just toss it back to the states. So the current consensus amongst Americans, unfortunate as it is, would probably just be decided at the state level. Yes, that means that a lot of states would probably permit homosexual marriage, but it does mean that a small handful would ban it.
All right. So we're talking about, or actually at the outset, Mr. Prudentialist in his opening remarks mentioned that the pro-life movement was one of the largest, most well-funded, and most well-organized right-wing movements in the United States. And, I could probably extend that to most of American history. There's only a few things that would really compare to it from a sort of legal perspective, I would think, from my having read of legal history. Once again, though, I'm not the expert in that. So, Mr. Prudentialist, do you think it would be feasible to see those efforts turn towards these other cases, most of which violate a lot of, traditional morality, not necessarily to the same extent in the eyes of most Christians as Roe v. Wade, but still violates morality? Do you think that switch could occur, and what do you think those movements would look like if it were to?
I'm not as optimistic that you could probably get a well-organized, or even take what existing infrastructure there is politically towards something like Obergefell or Lawrence or really any of the other major substantive due process cases that have sort of been that post 1965, how did we get to here sort of question. I do think that it is a lot easier to, like Sandbatch had said, to engage and sort of activate the disgust factor to it, that we are discussing killing, compared to some of the other more natural aspects of disgust that people do have reactions to with regards to the other cases. This doesn't mean that the other cultural issues that we're currently dealing with right now in wake of those problems could be addressed. Like I had mentioned sort of at the opening, there was sort of discussions about detransitioned adults wishing up to the age of 30, which was the legislation introduced that could give them the legal right to sue the doctors that had prescribed medications for transitioning. That would be the way to go. I mean, especially with what has been happening with, say, Christopher Rufo and others pointing out grooming and CRT in public schools. That probably would be the avenue to do so if we're going to protect children. The common left wing narrative always is, well, you really don't care about the children. You want to make sure that this birth is forced, and then you don't do anything after the child is born. So if there was any sort of mental strategy in mind, I would probably see that. Well, the right has open avenue to say, well, we do care about these children that are being born. We just don't want to make sure that they are being groomed and subject to predators and other sort of degeneracy.
All right, and I would tend to agree there. And the reason I asked you first, Mr. Prudentialist, I don't know if the audience knows or if I've mentioned it yet already. Like me, you did some organizing and work with pro-life groups. Would that be correct?
Yeah, I've done protests in front of a Planned Parenthood when I was back at the working at the Republican Party in the county that I used to live in. So I've done a little bit of that. I've done phone banking. I've done marches. So definitely an issue I'm heavily invested in.
And like me, you can, or rather, I share the opinion of you being less optimistic towards public opinion turning towards these other cases. And a lot of it ties into what Mr. Sandbatch was saying in his remarks. The sort of the mental disgust that a lot of people have towards abortion would be much, much harder to drum up for homosexual marriage, for, contraception. That one would be particularly hard, and it will tie into a subject that we'll get into later, because most Americans are, or I say a plurality, I believe, at this point, would be Protestant. And for whatever reason, most Protestants in the United States refuse to touch issues like contraception and increasingly homosexual marriage, and just continually view those subjects as a high church or a Catholic problem. Once again, though, we'll get into that later. So I would have to say I share your opinion of being less optimistic of public opinion turning towards those cases. Mr. Sandbatch, Mr. Mahler, do you guys have any comments on the topic?
Well, I would actually recommend that we go ahead and steal some territory the left has claimed on this. The right in the US has a bad tendency to let the left claim a piece of territory, and then we decide that, well, that's enemy territory, we have to hate it. This happened with the environmental movement, it has happened with a number of social issues, and it is a very bad strategy, and also it's just wrong. Environmental issues were originally a conservative issue, not a leftist issue. Of course, the version of environmentalism that they advance today is nothing like the traditional conservative case. We're not really so fond of going around setting SUV dealerships on fire. We leave that to them. But we shouldn't just cede this territory to them. And so when they argue that, oh, well, you hate children because you don't do X, Y, and Z, propose solutions for X, Y, and Z. Do we have major problems with our healthcare system? Of course we do. Propose solutions. Don't just let the left have that as their issue. It's not their issue. It's take it back. It's our issue. We have better solutions than they do. When it comes to childcare, don't just say, well, that's a leftist issue. No, we have better solutions. Take the issue back. That's an agree and amplify case where they say, well, you don't like children, you just want to force births because you don't want to have childcare. Well, no, of course you want childcare. Make it illegal for women to work outside the home. Childcare problem solved. You can agree and amplify on some of these things. But insofar as the momentum goes, yes, that's going to be difficult to sustain because, as you have all mentioned, the other issues are, if they're not necessarily all of them less important to other Americans, they are less comprehensible, at least readily comprehensible to them, why some of these things matter, why they're related. For instance, contraception is abortifacient. Most Americans don't know that because they don't actually know how it works. Granted, part of that is because of what they were taught in health class, because in health class they were just taught, oh, it makes you not get pregnant. Okay, but how? What does it actually do? And of course, it is an abortifacient because chemical birth control works in a number of ways. It first attempts to stop sperm from reaching the ovum, or first attempts to stop ovulation. Those two are kind of interchangeable, first and second. But third, it stops implantation. And if you believe that life starts at conception, well, there's your unique DNA. And we can go to Jeremiah, of course. I knew you before I formed you in the womb. But if we say that life begins at conception, well, then stopping implantation is abortion. So if we're banning abortion, we actually have to ban contraception if contraception is abortion. So now we're playing one of the most important games when it comes to law, and that's of course defining terms. If you can define the terms, it doesn't matter what the rest of the document says. You win if you know what you're doing, if you're competent. And so if we can say that birth control, so-called contraception, is, and I mean the word is there in itself, contraconception is the actual term. So if you can define that as being abortion as it actually is, well, then necessarily under anti-abortion laws, you've already banned it. But of course, that's an argument that you're going to make in the courts and in the legislature. It's not something that appeals to the average person because you start getting into defining legal terms and how things work in the law. And average people will just never be interested in those things. And so, yes, it is, again, more difficult to maintain that momentum going forward with other issues. But we do have to try. We have to find a way to appeal to those who were, to some degree at least, involved, engaged when it came to the pro-life issue and get them involved in these related issues. You just point out these are also pro-life issues. These are all related. It's all one package. You don't, the left isn't entirely wrong when they say you can't care about this one thing and not the others. No, of course we have to care about them too, just not the way they want us to care about them.
Alrighty, and Mr. Sandbatch, your comments.
Well, I was just thinking about like ways, like avenues of attack, and the substantive due process thing is that's the one Clarence Thomas is going after. But I was my white whale is always the public school system itself, and of course you refer to this is what they were taught in public school, public health. Really, I think the ultimate target for right-wing lawfare should be the abolition of the public school system, and I'm not exactly sure how you would, but I think you would have to go about proving that some sort of harm is inflicted on persons as a result of being as a result of being subjected to public schools. That's the one that I think would be that's the real masterstroke. If you could figure out how to do that, but I spent 5 years or so in working for Republican policy making apparatchiks, and the idea that they frequently cede total ground to the left is generally true. One of the things that's amazing is the lack of creativity in right wing policy organs. They're usually going to be hyper focused on a very small, narrow range of issues, and actually pro-life stuff isn't even one of them, really. That's almost a totally separate sphere that they shop out to someone else. So I mean, really what you're looking at is a problem of creativity, on all sides, and small picture thinking. This is a thing that Republicans are real bad about, is very small frames of reference, and they frequently miss, like,
Mr. Sandbatch, I don't mean to cut you off, but you are getting progressively more muffled. Please continue, though. I didn't want to cut you off because I want that line of thought.
Oh no, sorry about that. I'm on my phone, and the way I hold my phone, it tends to cover my microphone. Sorry about that.
But yes, do you finish the thought though? Republican small picture thinking.
Yeah.
system. This was something I want to explore, and I think we can more in time.
Well, see, I'm not a lawyer. I'm even worse than a lawyer. I'm an intellectual. So I've never referred to myself as that before. So I'm one of these people that will come up with like really half-cocked ideas, like that police departments violate the Third Amendment, and then I shove them off to my lawyer friends to figure out how to do that. But I mean, I think that's the sort of thing that I think the right would have to look at. Substantive due process is cool and everything like that, but I mean, like a real attack would be something like tossing out the public school system, because you do something like legally prove that it's the school system itself that's causing mass shootings, or something like that would be the real money shot.
I think that would be the FBI largely.
Yeah.
So before I throw this, I want more time for this. I feel like that's a very interesting turn that probably won't get talked about as much. Because I'm sure a lot of people, when discussing where to go from here, will be talking about those court cases and not necessarily the public school system. So, before I throw that over to Mr. Mahler and Mr. Prudentialist, I remember seeing in the last 2 years much more antipathy towards the public schools. There is a lot of hatred that just did not exist probably 3 or 4 years ago. People went from very ambivalent to a lot of them seethingly mad, especially as a lot of this sort of transgender drag shows and strippers come to light as being given a spotlight in these public schools towards small children. And one of the other things that I saw was one of my friends on Twitter and various other social media platforms was saying that a very successful right-wing slogan for the coming future would be "pull them out," as in pull your children out of the public schools. So this is an idea that has been floating around, but I have yet to hear anyone suggest that it can actually be done to the point of abolishing public schools. So, Mr. Mahler, what would your thoughts be on such a course of action?
I think fully abolishing the public schools would be a very difficult goal to achieve. I don't particularly like the goal, not because of the consequences of it. Given current conditions, abolishing the public schools would be an unadulterated positive, very clearly. I think we all know that. But at the same time, we are also conceding a point that I don't want us to concede. That's ceding territory to the left. It's saying, we failed here, they succeeded, so let's just burn the whole thing to the ground. Education is an important part of forming your future generations for your society. We want control of that. We don't want to cede that ground or erase it. The goal should be to take over. Now, practically speaking, the question arises, can we take over the current system as it exists? And the answer is probably no. Given conditions as they exist now, it would take too long and things would probably just collapse before we manage to take control. But we're at the point where we have to go through the crucible to get to the other side. The only way out is through. And what is the best way then to reach that other side? I don't think we can just dissolve the school system. I don't think we can take it over, but we can certainly destabilize it and protect our own people in the process. And the way to do that, of course, is vouchers. You want to fund your side while taking funding away from their side as best you can. And so if you make it so that it's just parents are permitted to choose schools, period, and you don't have restrictions based on, whether it's a religious school or whatnot, well, we win in that calculation, because that means our schools get more money. Our children are actually taught appropriate things, useful things, and it just further entrenches that line between the two sides, which I also think is good, because it makes the lines very clear for what is coming in the future.
All right, and before I throw the topic to Mr. Prudentialist, just to get a very quick thought, a large contingency of my audience will be very, very favorable towards homeschooling and classical education, things along those lines. And I know that they would probably ask themselves, in theory, regardless of how practical it may be, what would happen if one were to try to just dissolve the public school system. Because if I understand correctly, it seems that each state, at least nominally, controls their public schools, but they have oversight by the Department of Education on the federal level. Is that a fair characterization? And what would destabilizing or dissolving that look like in theory? Just to tease that idea out.
It was a case. I think it's around 10%. No, maybe it's more than that. But there is a certain percentage of the. And this is one of the reasons why this stuff is so important. The case that it was a Texas court case kicked up to the actual Supreme Court, I think was it, and it came to the conclusion that states actually have limited control over what they're allowed to teach in public schools because of federal funding.
I don't mean to cut you off, but you are starting to robot again. It's getting slightly angry.
I've got to move again, is what's going on. But yeah, no, it was
back
it was
out in the field.
Yeah, it was a case in Texas, I think, because a certain amount of public school funding does come from the federal government, and it was a case in Texas that was decided in such a way that it was decided that some disparate impact was occurring in, I think it was around El Paso, something with Mexican immigrants, and that states functionally, as a result of this decision, have no control over what happened. Very limited control over what happens in their own public school systems because of an element of federal funding that comes from the federal government. So the federal government gets input, and anytime the states run into the federal government, the states pretty much just get overpowered for all kinds of totally understandable reasons. I think that is the issue. But I mean, again, I'm trying to think about how you would go about getting rid of public schools, and I think. It's probably not doable right now. But anyway, I don't even know if that was terribly relevant.
Well, I appreciate the contribution. Mr. Mahler, just to get your quick opinion before moving on to Mr. Prudentialist, because you seem to have I don't want to say dissenting opinion, because it's not like you're taking the exact opposite, but you have a differing opinion, I suppose would be the correct way to put it, towards dissolution of public schools and whatnot. So once again, what would it look like in theory? And I presume that you will have a point at the end of that about why that, in theory, would be negative for the right, or maybe not. I don't know. It's bad for me to presume.
We are, to some degree, in the looting phase of representative government. And in keeping with that, if we can get funding channeled away from our enemies' institutions, which at this point, most of the schools, are enemy institutions. If we can take funding from them and give it to our institutions or homeschooling, however that happens to be done, that's an unadulterated win for us. And so that is a good goal. That's something that can be achieved. That's something that we have somewhat done in some places. And yes, a certain amount of funding is from the federal government. For those who are not familiar with how the federal government does these things, this is how it works. The federal government takes tax money through whatever tax it happens to take, and then it has this pool of money for, usually it's arguably for a certain thing. The tax was related to, say, the gas tax. And so that goes wherever it happens to go, your state, federal government. The federal government then has this pool of money that is arguably for a certain thing. It tells the states, we will give you this money back, or at least a certain percent of it. They always have to keep their cut. But, and this is the important part, but you have to do X, Y, and Z, or you don't get the money. And how that works in the case of the highway funding is actually a very good example. How that works for highway funding is the government will give you money for your highways. And of course, they took it from you in the beginning, which I'm not saying taxes are bad. Obviously, the Christian perspective is, pay taxes to whom taxes are owed. But, and yes, we could debate what's a moral form of taxation, the amount, but that's a separate topic. How it works for highway. Yeah, of course. But how it works for highway taxes is very simple. They tell you, you have to set your maximum speed limit below a certain level, and that's about 85 miles per hour. You've set it at 85 or lower. I think a couple places may have 90 now, but you can't set it. You can't say we have the Autobahn, do whatever you like. North Dakota tried that. It worked very poorly. Not because people were dying, but because the federal government said no more funding for you. And you also have to keep your drinking age at 21. So that's how they do what is called they have riders on this funding. They have tethers to it. And if you don't do X, Y, and Z, you don't get the money. And that's how they control the money and control policy in the states, because they don't actually have the power to just straight up tell the state, you have to do X, Y, and Z. That's outside the scope of their power. But because of the way the law has been interpreted, they are allowed to tell you, we won't give you this unless you do X, Y, and Z.
Alrighty. Now, you'll have to forgive me, Mr. Prudentialist. I didn't mean to keep you silent for so terribly long. I just wanted to get that, I wanted to get those lines of reasonings out for the audience. What do you think? Having all that information, do you think that this is a viable strategy for the right, focusing on the school system? Any thoughts on homeschooling versus vouchers versus, should we try to take over federal riders to for states to our will? What are your thoughts?
I'm going to go all the way back to left wing taking territory and right doesn't do anything about it, because the right wing, as much as the left is a terrible victim of presentism. I mean, Roe v. Wade case from yesterday, right? The left gets this prospect that everything is going to come to an end and that their perfect progressive way of life will be over in a matter of minutes because the powers that be are against them, despite the fact that they really are the powers that be. I mean, consider that, gay marriage is so recent from 2015 onward that it wasn't until the 2016 election that it was even openly campaigned on or discussed. I think that needs to come in mind, that once something is ruled, that whole not just legally, but the conception of just settled doctrine immediately hits the American political psyche, to where we can't ever go back and talk about things that should be repealed or that have the potential to be repealed. I mean, I know that Murray Rothbard is famous for the argument of repealing the 20th century, and that seems just very laudable, or a very large mountain to move, but it does kind of show the presentism that affects us. In regards to public education, it would be interesting to see how you would even try to bypass the disparate impact, and more or less how Christopher Caldwell points out, basically our second constitution with the civil rights regime. And this was something that I was talking about last night on Pat Casey's stream, was just that I'm a little concerned that as Democrats, I think, will try and codify, or at least provide some sort of attempt for reproductive health care as their guise, because healthcare has been sort of their gateway entry to use disparate impact to ensure that Medicare and Medicaid can be amended to the ways that they need to, and provide incentives to ensure that there's equitable distribution to correct, historical disparities in care. So I do think that may be the avenue that we see in the future, and probably would be for public schooling ad nauseum. I mean, the real target, I think, would be the conceptual aspect of presentism, but until we can manage to find a way to legally strike a harpoon or spear through the heart of disparate impact, I'm curious to see how a lot of these things would go. This doesn't mean we shouldn't pursue vouchers and homeschooling. We absolutely should. I think the work that Corey DeAngelis and others have been doing for the last several years is proven to be quite exceptional, even in blue state areas.
Now, before we change topics or pass the question on to other panelists, what do you, Mr. Prudentialist, think that what do you think is the most successful, avenue for success for the right now? Because I reckon most of us before yesterday would have said going after Roe v. Wade is the most probable of success. It's the most the most morally repugnant thing that's on the books, probably. A lot of these arguments would have been said. That's done now. What do you, Mr. Prudentialist, think would be the most successful avenue of attack, if you will?
I mean, banking on disgust has been a pretty surefire way of working. I mean, putting things in people's faces and making them face uncomfortable truths and realities, at least politically, has been the avenue that worked for a lot of pro-life activists, sort of illustrating this is what you're actually doing, which is killing, which was kind of nice to see the mask off moment in that Atlantic piece the other day. But so when I'm seeing a lot of left-leaning individuals, or say, the Red Scare crowd or whatnot, talk about, oh, well, the Republicans are too busy tweeting about Drag Queen Story Hour or something like that. I don't think they understand that the reason why the right tweets about this or talks about it is because there's that innate disgust factor that you're telling children to go sit in a gay bar in Austin, Texas with big pink neon lights that's saying it's not going to lick itself. Yeah, there's a reason why we tweet about that. It's disgusting, it's degenerate, and it's immoral. Like, you're grooming children. We're basically going back to a full circle where the greatest trick that sort of the gay rights movement ever pulled off was trying to disassociate themselves from predatory behavior and pederasty, and we've come back to that. So I think that hampering on cultural issues and finding the legal avenues to address them is going to be the avenue, I think, for now to go forward from.
Alrighty, and before we switch topics, Mr. Sandbatch, Mr. Mahler, do you all have any comments on what Mr. Prudentialist has just shared?
Oh, just one theoretical question more than it is anything else. How does this sound to y'all? Can you hear me, by the way?
Yes, you seem good for me.
Yeah, okay. This is a question. This is the school shooting thing again. The school shooting thing has really been bothering me because it is problematic to have people shoot up schools all the time. It does happen here more than it does anything else. But let me ask you: is there a possibility that you could link the phenomenon of school shootings specifically, possibly to disparate impact on young men who are subjected to the conditions of public schooling? And if you can do that, and maybe you can use the left accidentally to help you, because I'm sure there are plenty of leftist lawyers who are angry in one form or another about the way some incredibly small minority is being treated in the public school system. Maybe it's Afghan immigrants. I don't know what it is, but I mean, that seems like you could, I don't know that you could eliminate public school systems entirely, but I think it moves along with a general tendency in American life to at least nominally want to increase the choices and the autonomy of individuals. I think if you combine that with the possibility that subjecting young men to the conditions of the public school systems creates a behavioral problem where they come back to school one day and shoot up their class, that there's a possibility there. That's just in my mind, but I think that's the kind of the possible. And I hate to come back to this again, just because but I've got a lawyer on the line, so I'm like, how does that sound? All
right, Mr. Mahler, your thoughts?
I think you would have a very hard time proving to the satisfaction of the court the connection between those two things. And generally speaking, when you have a disparate impact case, the court just orders someone to throw money at it.
Yeah.
So that would be your major problem. Is even if they found it, they would probably just order the state to throw more money at the problem, which would just mean hiring more incredibly useless so-called professionals. And so you'd have, one teacher and 15 psychologists in the classroom instead of anything else, which, yes, you're going to make the problem different, not in a good way, but that's most likely what the court would do to try to solve that issue. And so I just think the best thing we can do is erode the institutions that are contrary to us. I would prefer to take them over, but I don't think we can.
Alrighty. Does anyone have anything else that they would like to add to the topic before we move on?
I don't think the disparate impact part relating public schools to school shootings is probably the best avenue. I think Mr. Mahler had said it best earlier that that's more of an FBI problem than a public school issue.
Oh, you're feeling sad and alone and you're in this chat room? What if I told you I could give you a gun?
Yeah.
No, of course I'm a 13-year-old girl. I'm not a 47-year-old FBI agent sitting somewhere in Virginia. You should listen to me.
Of course you can buy $10,000 worth of equipment from your part-time job at Wendy's.
Your allowance from your parents is enough to buy this gear, right? You can certainly do that. Oh, you found it in a locker somewhere?
Alrighty. Now, the next topic that I wanted to discuss was yesterday I saw Mr. Keith Woods share a plethora of information tying the evangelical movement and their fixation on abortion, not to any sort of moral righteousness or anything like that, but rather I believe it was the founder or one of the first leaders of the Heritage Foundation trying to direct attention away from segregation and racial issues and trying to unite the evangelical movement around other less controversial issues. So, if I remember correctly, he tried prayer in schools and that didn't work, and he tried something else, and I can't quite remember what it was off the top of my head. It might have been contraception. But eventually, he settled on abortion, and that seemed to him to be the most galvanizing piece of legislation or court interpretation, I suppose we could call it, that was in American society at that point. So this was particularly interesting to me because I had only seen this line of reasoning from extremely left-wing organizations and magazines and news outlets. I hadn't seen this from the right wing at all. So it certainly seems very interesting that would come from the right. Now, does anyone have any preliminary comments on the issue, the evangelical movement being tied to abortion as a means to get away from segregation? How true is it? What are your guys' thoughts? Just take it from there. We'll start with you, Mr. Sandbatch.
None of the information in any of that. First of all, I'm not sure what his positionality is here. I'm not sure why this was something he decided to post, but it is mostly true. And really, what the important thing here is that really the conservative movement, as we think of it today, it dates to about 1970, around the time of both Roe v. Wade and the Watergate scandals. Okay, so prior to that, Joe Biden's he first entered Congress in 1968 or something like that. He was an early adopter of what would become the new paradigm in politics. Evangelicals were not a large force in American politics or even really in American life prior to the 1970s. You can make some arguments that it goes back to Goldwater but you remember Goldwater lost. One of the things that this group of people had to deal with was that there was very little that politically unified them, and if you left them to their own devices, they would start arguing about theology amongst themselves, and they didn't have a political program or anything so whenever the old, what we would call the bipartisan Atlanticist or New Deal consensus started to break down around the time of Watergate, the Buckley types, and of course William Buckley, an Irish Catholic, and the people who made up what would become the moral majority in the new conservative movement had been up to that point. A lot of them were Wallace voters in '72, and that was kind of the last hurrah on when it comes to defending segregation. Yet in the 1950s you had the decade of massive resistance, and then in the 1960s you had all the civil rights violations, everything like that. But up until about 1975 or so, the main avenue of conservative resistance in America, or conservative politics in America, was essentially the opposition of civil rights arguments. But whenever mainline Protestant churches sort of fell by the wayside, and they did so, there's a great book on this called The Spiritual Industrial Complex that talks about how the mainline Protestant churches were essentially nationalized and involved as participants in the Cold War. And this ended up spending a lot of what you would term their spiritual capital, because they would start to take positions that weren't necessarily Christian in nature, but they did fall in line with the American overseas agenda and fighting proxy wars against communism. And evangelical churches started to really skyrocket in members, because people were they were looking for something that was a bit more Christian than it had been. And one of the big issues with the decline of this group and the rise of the evangelical groups is that there are two other groups in American politics that already they were relative newcomers, but in the previous 20 or 30 years they had seeded themselves and they had started to win a number of victories. And this is one of the reasons why whenever I was talking about Loving versus Virginia, why that case is, you're never going to find a conservative. It's certainly on the current court. You're not going to find somebody that's willing to even talk about Loving versus Virginia, because Loving versus Virginia was based, the lower court case that's cited in Loving versus Virginia is a case that was brought and funded by the Catholic Church in Southern California. And so these other two groups are the Roman Catholic Church and American Jews. Okay. And they were positioned well in the 1970s whenever evangelicals came on the scene with a lot of bodies, but not a lot of really good ideas about what could be a unifying agenda. And so these social justice issues that Catholics and conservative Jews had been spending a lot of money and time on for the previous 2 decades or so, became something that conservatives could rally around. Now, the flip side of this is that a lot of these old WASPy type laws, like miscegenation laws and anti-civil rights laws, they restricted Catholic and Jewish autonomy as well. And so those were not good cases. Those were not good issues for this new moral majority to pursue. And so they needed to find something else to sort of rally around. And abortion is the one that they kind of settled on. And this is the reason I thought this was kind of a strange thing for him to be posting, because you said I usually see that kind of argumentation coming from the left, and this is because every one of those screenshots he posted that was from a like raging leftist historical source, because that's how they talk about this. And that's the way the left has viewed the last 40 years of American history or so, that they're talking about abortion, but what they really mean is to segregate blacks, because the left has a little bit better memory sometimes than we do. And they remember the 1970s whenever the anti-abortion law really was, for many white evangelicals, it really was kind of a skin suit for civil rights laws. It's restricting. The left will like to talk about restricting the behavior of black bodies and that sort of thing. So that's where that comes from. So I wasn't really sure why he was posting that, but everything in it's more or less factually true. It just it's a wonky argument to be posting yesterday.
Alrighty, Mr. Prudentialist, we'll go to you now. Your thoughts, implications, extrapolations, whatever you have, and then we'll go to Mr. Mahler.
Well, I thought Sandbatch pretty much kind of hit it on the head in regards to the historiography here of where the sort of the moral majority fusionistic part of the right wing really does emerge from, in sort of this conglomeration of this now newly energized and funded evangelical movement in comparison to taking on parts of conservative Catholics and Jews. I mean, that's just part of American history and its political coalitions. And that's why the pro-life movement is one of the more well-funded and well-organized ones, is because this is an area in which you can get basically all Christian factions in the United States to sort of get lumped together and organized. I mean, at the National March for Life, this is where you'll get American metropolitans, Catholic archbishops, and evangelical preachers and reverends to come up and have their speeches and conversations alongside Orthodox rabbis. So yeah, I mean, it's part of it. I don't know the positionality of it, other than perhaps just race coming from Mr. Woods' post, but I won't speak on his behalf. But yeah, I mean, this is just a part of American political history where sort of the WASP old right order pre 1965, really the 60s is when the old right dies, and here we are. So I don't have too much to add other than that's pretty good historiography.
Alrighty, Mr. Mahler, your thoughts. I don't think I sent you the post, and I don't know if you saw it, but I think hopefully you have enough context now to talk about the issue.
Context.
All right.
But the fundamental problem with the American right is that there's no coherence to it whatsoever. You have, as much as we like to point out that the left is basically a coalition of the degenerate and the insane, which of course they are, and it's a bunch of little groups that often don't have much in common aside from their evil. the right is a bunch of little groups that also only have a handful of threads connecting them in some cases. And so part of it is just practical politics. You're going to have to build coalitions. And that is something that Americans are perhaps less accustomed to because our system is not made for building coalitions. That's something our European brothers would be more accustomed to because coalitions are just how you run a government in Europe in most places. So there's nothing necessarily wrong with having to build a coalition to achieve an end. The challenge, of course, as we noted in an earlier segment, is keeping the coalition together once you've achieved that particular end in order to achieve further ends, which is what we're now trying to do. Of course, if you can make it look like that further end is just a natural part of what you already achieved, it's easier. But holding together a coalition on the right is a very difficult thing to do. And that is particularly the case when it comes to American Christianity, because American Christianity is insane. We have such a wide range of people who are Christian or at least claim to be Christian in the US and agree on virtually nothing. So you have, evangelicals so called in Texas who are as rah pro-Zionist as it is possible to be. Then you have Lutherans in the Midwest who are very much the opposite of pro-Zionist if they are proper Lutherans. And so trying to get these groups to agree on anything is very difficult. You're going to descend into infighting almost immediately unless you can get them to focus on something on which they happen to agree. And abortion was a great issue for that because it's literally murdering children. I think we can all agree we don't want to do that.
Alrighty. Does anyone have any other comments they would like to add? Any responses? Any extrapolations? Mr. Prudentialist?
Oh, I mean, he's not wrong at all. The right will always bicker at a million different things at all times. The right, unfortunately, doesn't have sort of this academic political theology that allows it to sort of operate into a hierarchy of issues. Like the left is really good with this intersectional stuff where virtually everything can be put in these disparate little niche degenerate groups can all be sort of unified towards a greater progressive direction. This is how you can get gender, environmentalist, racial, economic, what have you, organized collectively to achieve issues that may not directly affect them, but via this sort of intersectional lens that it can affect them through some minute way because, there's this collision or avenue in which environmental justice equals racial justice. I mean, we can look back at virtually every sort of publication as to how this works with social engineering, Edward Bernays, the Tavistock Institute, etc. The right doesn't have this. We had, of course, sort of the fusionist framework, which I really do think is a big ideological component as to how the right got to where it is right now, which is a little toothless. But that's my take on it. I think Mahler's absolutely right.
All right, Mr. Sandbatch, I believe you will have a few comments that you would like to make, and I'm very glad that you've signaled that because I was about to ask you directly. So, Mr. Prudentialist has mentioned the Tavistock Institute. Can you give a brief summary for our audience? You and I should probably revisit this on a later stream to go further in depth. What is it? What relation does it have to anything that we're talking about? And what does it mean for us? Mr. Sanders.
Yeah, I was going to try not to bring it up, but Prude tickled my itch. The Tavistock Institute's a coalition of psychologists, and he mentioned Edward Bernays as well. Edward Bernays was loosely affiliated, but he actually came a little bit before them. It's a group of people. It's a group of psychologists mostly who were very involved in engineering the post-World War II order, and intersectionality is properly, that's definitely them. But the idea that the right doesn't have, a sort of Tavistock influence operating on it is also incorrect, because really what the Tavistock Institute does, and I don't want to make it sound like this like one shadowy cabal of like 5 or 6 dudes is directly controlling the behavior of like millions of people, because that's not so much the case now. And they were very influential in the 1960s and the 1970s, and the ideas on concepts like group dynamics, group psychodynamics in particular, have been are very influential, and where if you work in a corporate setting, these are the people that invented corporate culture. These are the people that invented sensitivity training. These are the people who invented and engineered the existence of what we today call fandoms. But they also have in their concept, they have their main working concept comes from a guy named Wilfred Bion, and he is a pioneer in the field of group dynamics, and he came to the conclusion that any group of people is actually a group of groups of people that are always interacting with one another. And so he comes to the conclusion that there are two types of groups. There's a working group, which is an association of people that have a common goal. And then there are what are called basic assumption groups, which are coalitions that form inside the working group that may have oppositional agendas and may not be cooperative with the main goals of the working group. Okay, and so in any coalition, so in this sense, the left and the right are both coalitions inside the larger working group that is, the American government or so. Well, if you want to control, there are two ways you can control the behavior of these basic assumption groups. One of them, and this is where Kurt Lewin and all his freeze, unfreeze, I think most people would be at least nominally familiar with Kurt Lewin. If not, it's not really important. But one of the things that he recommends doing is freezing the behavior of some groups and unfreezing the behavior of other groups when according to the needs and desires of the working group that's working towards a cooperative goal. You can kind of engineer dissent and assent this way by feeding some groups information that causes them to become more cooperative, and feeding other groups more information that causes them to dissent. The American right is the name of the basic assumption group in Bion's categorization of groups that the American right largely fits under is the fight or flight group. Okay, and so I think it's a little naive to believe that the right just doesn't have an organizing theology the same way the left does. I mean, the left has been given one because they, especially since the 1980s, they have really since the 2000s. In the 1980s, it was actually the left that was, sort of frozen in the space that they call the cultural turn. And that was when intersectionality became a very big deal among them. And of course, it led to immediate infighting about where exactly the the sectionality line starts. But the right has also been subjected to a lot of these group dynamics and pressures exerted from above, which is, the way you handle, according to Wilfred Bion, the way you handle a fight or flight basic assumption group is one of the characteristics of them is they will tend to break down and start, if they don't clearly have a goal that they can, or someone that they can focus on as the single unifying cause of their imminent doom, then they will immediately break down amongst one another and start fighting over what actually is the most important thing that is going to affect their immediate ability to thrive. And so, I think it would be a little naive to think that the right simply doesn't have one of these organizing theologies. There's conscious noise being injected into the system, not by the shadowy cabal of the Tavistock Institute, but by the large network of think tanks, NGOs, so on and so forth, that are sort of the progeny of the Tavistock Institute. Did that answer the question? I think I got real abstract.
No. You gave an explanation of what the Institute is, how it's affecting the right, and all of it. A very, very sophisticated form of control being exerted that's very hard to detect. So, Mr. Mahler, if you have any brief thoughts, I would like to hear them. I would mention to our panel, we are nearing our end. I would like to go for at most 25 more minutes, and 20 to 25 more minutes. And I have about one other topic I want to get to, and then the closing. So, Mr. Mahler, your brief thoughts, if you have any.
I would just add one more point. And that is essentially, at present at least, the right has no leadership, which is a significant problem. I ascribe to the great man theory of history and related theories, so that's where I'm coming from with this. But the right doesn't have any leadership around which people can rally and move forward. The left has always had leadership, which is a fundamental difference between the right and the left. And the left will always have leadership for reasons that are obvious if we hearken back to the comments related to scripture and good versus evil. The left will always have leadership. We need leadership if we are going to be organized and focused enough to continue to counter them effectively.
Alrighty, and I think that is a very good end to that topic. Now, the last topic that I wanted to discuss, and I have sent a visual to Mr. Prudentialist, who hopefully can share that, is Roe v. Wade being overturned, as we've discussed many times, and hopefully as you, the audience, have seen elsewhere, has not just been outlawed in the United States, it has just been thrown back to the states, meaning that each individual state can, choose its own legislation about abortion. So this means, once again, as we've been mentioning, the battle is not over. Now it is much more local. So I saw this being thrown around by a few people yesterday. Most notably, I believe I saw it from Nick Fuentes, who has a very large following. Mr. Prudentialist, you do a lot of very local organizing, and you seem to have a very superb knowledge of how each sort of state what it leans towards, conservatively, liberally, progressively, etc. So how does this map look for the audience that can't see at home? The dark red states are the ones where abortion is illegal by trigger law or by other legislation that made abortion illegal effectively immediately. The sort of tan-colored states are the ones that are expected, according to this map, to make it illegal. And the blue states, the ones in blue, are the ones where it is legal. So, Mr. Prudentialist, your assessment of this and your thoughts.
Well, the map is pretty accurate. I mean, we've already seen Oklahoma, Texas, Kentucky, and South Dakota sort of initiate their trigger laws. There are 13 states that do have them, where either in the coming days or within the month there will probably be a de facto ban on abortion based on the fact that Roe v. Wade has been kicked back to the states on the issue. So, for instance, yesterday, the Attorney General of Texas, Mr. Ken Paxton, had basically declared the day a holiday for life and told everyone to go home and just left with no further statement saying abortion is illegal in Texas writ large. But the other question also is that this map isn't entirely accurate. I believe Governor Glenn Youngkin, a Republican who now takes the governorship in Virginia, is saying that he will probably do something around 15 to 16 weeks for that, which, considering his state and how powerful Nova is, it's a good sign. But this map is pretty indicative of what we are going to see. There will most likely, we will see bans based upon the composition of their state legislatures. And now that the debate has been kicked back to the states, this is where how strong your local party is, both in terms of just how the party stands, how you're going to participate in precinct conventions. This is where the local politics really does matter, because you do have to show up to these sort of conventions, you do have to protest, and state legislators are a lot easier to hold to account than those in Washington. So if you want to really take the momentum, then you have to take the momentum home. You can't just protest outside of the Supreme Court or donate to the national pro-life movements. You would need to start really hammering it at home.
And I would agree. And I remember, I believe it was on your channel when the draft, or the decision rather, was first leaked. We got inklings that they were going to overturn a few months ago. I believe we had that discussion on your channel, Mr. Prudentialist. And one of the things that I was surprised about was I had always marked a state like Kansas as being very conservative. But the information we were operating under on that stream, I seem to remember, had Kansas not outlawing it. But on this map, it is. So, just small. I'm sure that's not the only state in the union that would be in that sort of gray area, if I'm remembering correctly. Could you give a little bit of elaboration towards that point?
Well, Kansas is, despite its sort of long-standing Republican rule and it being a red state, has its own internal domestic political issues. Keep in mind, they have a Democratic governor now. So that probably would be something to keep in mind, considering how well that Kansas tax experiment has been going. So, not to mention just there's also certain demographics that you have to keep in mind with your electorate. But whether or not, I'm sure the Kansas state legislature will easily try and pass something. The question is will they have a veto-proof majority with their Democratic governor?
All right. And are there any other states that might be in such a circumstance before we pass this off to our other panelists?
Michigan and Wisconsin, just by nature of Governor Whitmer and the tense political situation that they might be thinking in regards to 2024.
Alrighty. Now, let's go with Mr. Sandbatch first, and then we will finish off with Mr. Mahler on this subject. Mr.
You
Sandbatch,
didn't use my map. My map was way better. I was
sorry,
way more. I was way more detailed. I didn't know you had one. Otherwise, I'd have sent it to you. Except there's a typo in the title, so it says abortion, and so that's sort of problem. Like the problem with Wisconsin is that Wisconsin doesn't have a real ban. They have a pre-existing ban, and so that means they had a ban on abortion before Roe v. Wade, and given the political constitution of Wisconsin, they're probably pretty much done. They're just going to reverse it. But the only two states, the states that I think are real interesting where there's going to be a fight, are in North Carolina and Virginia. Of course, that might just be my Southern bias, but those are two indicator states that I think you'll be able to use to tell the way. I use them for everything, and I think if we could get abortion bans run through North Carolina, Virginia, and Pennsylvania is another interesting sort of debate point that might fly our direction. But those are the three states that I think are going to be very indicative. I mean, Kansas is great and everything, but Kansas, I don't like to disparage the people of Kansas, but like North Carolina, Virginia, and Pennsylvania are battleground states that could be very indicative of the direction the country is moving politically. So if there's going to be any grassroots movement from the right, I think we'll start to see it in those three places.
Right, and I wasn't mentioning Kansas because I thought it was some great focal point. It's just I remember that surprising me the last time.
Yeah.
And here this map where people saying, well, they think it's likely they'll ban. And
I think,
forgive me for using your map
I think Nebraska is another one, but these Midwestern states, I don't really know much about them, and they're kind of according to their own internal rhythms. Like some of them only have one. They have unicameral state legislatures and all that stuff. That fascinates me, but I don't know much about it.
Alrighty, Mr. Mahler, your thoughts.
Well, I guess I could just say it's the Civil War II map. If that happens to eventuate, those are effectively the lines. Although there'll be obviously some movement, because you will actually have some people who will move out of certain states and into other states. Granted, they will do it only partly because of the changing laws on abortion, because there'll be a number of other incentives for why they do that. This may just be the final straw for some people, which is good, insofar as it leads to clearer lines between the right and the left.
All right, and that I would love to talk about population movement and all that. If you guys think that we can sufficiently clear up that topic in about 10 minutes or so, I think we can move on to that. If we're done with this, do you guys have any more comments as to this map, as to local action, anything like that? By all means, please speak.
I do think that we'll see some migration out of some states. The question is that I don't how much, because I don't think it'll be a particularly significant amount, but everyone from Disney to Dick's Sporting Goods to Google has already said that they'll pay for relocation, crossing state line travel expenses to go kill a child. So that does we will see this summer really the power of woke capital in action in regards to what sort of benefit package we are. So for all of those lean in girl bosses that are hate watching this video, do not worry. I'm sure that your boss has no problem paying for you to kill your child for the sake of your career.
Any other comments?
The only problem I have with the population differentials, because really what this becomes now is a set of differential equations. So like take Wisconsin or take Minneapolis, for example. Minneapolis has seen, I mean, Minnesota has seen large outflow of people in the last 10 years, but all of the conservatives moved to Florida. Okay. And so like there's this, if to not to get too, like Tavistock white knuckled on this, but I think there is a scheme, a macro level scheme that encourages conservatives explicitly to move to Florida. It encourages leftists to move to Nashville, to Atlanta, to Huntsville, and to places where they perceive that the population differential could bring these areas within the margin. Okay. And so I think the left is considerably better at distributing their population migrations than we are, because everybody's like, everybody needs to go to Florida. They got the best business laws in America. And so like 100% of people, of right wingers that are trying to relocate, they move to Florida. And so that flips Florida solidly red. Yeah. But all of these other states, Tennessee, the central Tennessee Valley, East Tennessee, West Virginia, these are places that are starting to see lots of very leftist bourgeoisie inflow that are constantly, maybe not quite yet, but they're starting to threaten the conservative majorities in those areas. And so I think if this is a game that we want to play, again, we need to not play defensively. So like, Florida is probably in the win column permanently. So like not everybody can move to Boca Raton anymore. You got to go somewhere else.
All right, Mahler, your home state has been, or not your home, your state has been mentioned, and let me see. Yeah, any comments, Mr. Mahler?
Well, my home state should probably, although it depends on how we define home state. At this point, it's Tennessee, originally California, so it depends on how you're looking at it. One thing you can definitely take away from looking at this map is where you probably don't want to be in the coming decade or so. And that, of course, would be the obvious ones, California, Oregon, Washington, and the Northeast is less clear because some of that is because of libertarian influence, more so than outright leftist influence. Just depends on which state you happen to be in. But yes, you can influence politics to some degree with population movement, but no, the right is probably not going to pull that one off. So you want to be where it is safe to be for your family. And that's not going to be the West Coast for the large part. Yes, Eastern Washington is very different from Western Washington. It's also a desert and it's not very pretty. So, pick somewhere it's going to be safe for you to live with your family that is going to have somewhat sane politics, at least in the coming years. And this map is a pretty good indicator of where those places are.
Alrighty, we have time for any last comments on this subject, if anyone has any. Alrighty. Well, I think that we've covered most of the topics that I want to cover, unless anyone else has anything at all that they would like to add. Any topic we haven't brought up, anything that we've glaringly missed. And it doesn't seem like it. All right. Well, I would like to revisit each of our panelists to allow them to give some closing thoughts. And after that, I will ask each of you where we can find you, and then I will close us out. So, Mr. Prudentialist, your final thoughts.
As I said at the very beginning, a strong moral victory, but there is still much more work to be done. This doesn't mean that we shouldn't celebrate this. This is obviously a huge win for us. But again, there is still more work to be done. Do not forget, the right has this.
Mr. Sandbatch,
we're gonna edit that one out. That's gonna be on you, buddy.
If you would like to start again.
Anyways, huge win, but there's still much more to do. Do not fall into sort of the goldfish memory that sort of the right writ large has a problem of sometimes, where we take one thing and then we sort of forget everything else. Don't treat it as a political release valve, and I will leave it at that, because there is still plenty more work to be done.
Mr. Mahler, your thoughts.
I would echo that, yes, this is a victory. It's very important. I would say more than just a victory, it is an important propaganda point. Use it to mock and attack the left. Mocking people is extremely effective, and the left are very easy to rile up. They go off the deep end very readily. So if you can get them to just go insane, which some of them listening to this may be doing it right now, great. Just use it to needle them. Yes, it's a moral victory. Yes, it's important for our side. Celebrate it, but it's also a weapon, and use it against them. Because if you continue to make your opponents look ridiculous and insane, it does help your side. Because if you have people who may be on the fence and they look at one side that's out screaming and setting things on fire, and the other side that's just sort of needling them, it's not very hard to pick which side you want in your neighborhood. So, important moral victory. Yes, the work isn't done. Yes, we have to take this and leverage it into further victories, but it is important to recognize we did win. Take that as a win, celebrate it, and advance from there.
Alrighty, and Mr. Sandbatch, your final thoughts.
Well, it's more or less how I said it. Again. If the cheerleader is what you want, somebody said to somebody called me a pessimist the other day, and I said, yeah. I was like, well, I will. The first time I smile is when everybody else is getting measured for their victory parade uniforms. But I do. Yeah, this is a huge win. But the takeaway from my perspective, again, it's like I mentioned, that post-Watergate alignment of American politics that people have been so famously saying is starting to crack. And the last 2 years or so, we've seen it more or less implode. The classical Republican strategy for winning elections has broken, whether by hook or by crook. Breaking the blue wall doesn't work anymore. The issues that the two large factions in American politics have to argue about are starting to decrease. Okay, so some of these issues are being definitively settled now, and one of the historical parallels that I would draw is that this looks very similar to the United States in the 1850s, when tariffs were decided one way, when various constitutional issues were decided another way. And so the docket of things that are contested is starting to shrink somewhat. And in the 1850s, it shrunk to slavery, and then we fought a huge war because that issue ended up being unresolvable. And I think this is certainly a win, but this is a very dangerous period for the United States as a geopolitical entity, because the grounds for contest are starting to shrink, and it's kind of got the same effect of the dry season in the Serengeti, when the wildebeests, when they go to get water, they got to stand right next to the crocodiles. And so the potential for violence is especially heightened right now. Violence of all kinds, physical violence, political violence, so on and so forth. It should be very interesting to see how these issues play out over the next few years.
And as for my final thoughts, I don't know that I have much more to add than to echo our very wonderful guests that have joined me today. I would say that if you are in any of those states where your abortion laws might be on the fence, this is something where what you do can actually have an effect, unlike a lot of what you might perceive at the federal level. So, at the very least, I would say, invite families over, eat with them, try to get them to help you organize. If you don't want to do very much, if you want to go farther, try to meet with donors, try to get them to, turn their gaze towards your state, your statewide effort rather than the federal one, because that's where you need it now. You need it on the local level, on the state level, more than anything. I believe it was Mr. Prudentialist who earlier said, don't just let them donate to the national pro-life movement. Get them on the state level. And this is something that you can most definitely accomplish, because it's a lot less daunting on the state level than it is on the federal level. With that being said, I think that we can close the topic. Hopefully, I will have your links in the description whenever this video goes up. But just in case I mess something up, Mr. Prudentialist, where can our great audience find you?
You can find me on YouTube as The Prudentialist, as well as on Odyssey, I have a Substack called Prudent Observations where you can find me there as well. Telegram, Twitter, all sorts of things. You can find me at the wonderful findmyfriends.net/the Prudentialist, like many of our friends in our circles do. And as always, thank you for having me on. And if you aren't already subscribed to me, please take the time to do so.
All right, Mr. Mahler, where can our audience find you?
Easiest way to find me is just my website, CoreyJMahler.com. I am also on Twitter, Gab, Telegram. We'll see how long Twitter lasts anyway this time around. But the easiest way is the website, since I can obviously update that, and I'm not going to get banned from my own website.
Alrighty, and Mr. Sandbatch, where can our audience find you?
See, I have the Substack Esoterica Americana, which, like I said, has like quadrupled in subscribers since the last time I published something. So I need to get something. I got like 5 drafts that are coming, and there's usually long form content, so it takes a while to do stuff. But then I'm also on Telegram as again Esoterica Americana, and you can find me on Twitter if you want to at Christopher Sandbatch.
Alrighty, and as a final note to my audience, if you like the work that I do, I will have my Subscribestar link in the description. Your donations are very much appreciated, and you can find me also at findmyfriends.net that Mr. Prudentialist just suggested earlier. And one final update, I'm going to try to be doing this Saturday mornings regularly, probably at 8 a.m., and if YouTube finally gives me the often desired privilege to stream, then hopefully that will be going live rather than uploaded at who knows when this is going out. So be expecting that. I look forward to where this can go. And with that being said, I think that we're ready to sign off. Thank you for watching, everyone, and have a good day.